Thank you so much to our speakers and our audience members for joining us today in a conversation that's very relevant and timely, the future of universities. This will be an interactive session, so invite audience members to post questions in the Q&A tab at any time during this webinar, and towards the end of the discussion, the panelists will address it. My name is Sheetal Kalantri, and I am Associate Dean, Professor of Law at Seattle University School of Law, as well as the founding director of the Roundglass India Center. The center is an interdisciplinary academic institute focused on the study of contemporary India and Indian Americans. Our key goals are to educate communities about issues relevant to India and Indian Americans, connect the United States to India, and give back to both countries. When the Roundglass Center created this webinar series in November, we did not anticipate the pace of change we would see, as I'm sure none of you did. The webinar today was mostly intended to focus on the consequences of the affirmative action decision on 2023. Yet, since January 20th, we have seen so many varying threats posed to universities that we broadened this conversation. The administration has used threats of funding to cut, to make demands on universities that deny trans rights to people / DEI programs. They have deported people on student visas for exercising their First Amendment rights. And in the last few days, students' visas have been revoked for minor infractions on their record. This has never happened before. Earlier this year, the administration made broad cuts in science funding and recently has begun targeting specific universities for purportedly not doing enough to combat antisemitism. Just yesterday, it was announced that Trump officials have frozen $1 billion in funding to Cornell, a university that every speaker today has some connection to. I'm an alum and former clinical professor at Cornell. President Peñalver was dean of the law school, and Professor Dorff is currently a professor there. We at universities have felt battered in the last few months, but this new action really hits close to home. The actions against universities have impacted everyone associated with them or anyone who wants to be. Given the focus of the India Center, I just wanted to highlight the few ways in which these actions particularly impact Indians and Indian Americans. The arbitrary revocation of student visas impacts students from India. In the last few years, Indian students have become the largest student population in the United States, exceeding China. The number of Indian students in US reached an all-time high of 331,000 in the last academic year. Indian Americans are impacted by the university decisions on affirmative action and DEI programs. A significant number of science researchers and faculty members are of Indian origin at US universities, and they are no doubt impacted by the funding cuts. To discuss the legality of the government actions and what they mean for the future of universities, we are so thrilled to have higher education leader President Peñalver and nationally renowned law scholar Mike Dorff to join us today. Although they both need no introduction, I still will do a short bio for them before I invite them both into the conversation. President Peñalver is the 22nd president and professor of law at Seattle University, prior to which he served as the dean of Cornell Law School. His scholarship focuses on property and land use, as well as law and religion. His work explores the ways in which law mediates the interests of individuals and communities. He received his BA from Cornell University, JD from Yale Law School, and was a Rhodes Scholar at Oriel College in Oxford. He clerked for Judge Calabresi, as well as the late Justice John Paul Stevens of the U.S. Supreme Court. He previously served as the John P. Wilson Professor at University of Chicago and has been a visiting professor at Harvard and Yale. Mike Dorff is the Robert S. Stevens Professor of Law at Cornell University. He is a leading constitutional law scholar. He has authored and co-authored well over 100 scholarly articles and essays for law reviews, books, and peer-reviewed science and social science journals. He writes for Justia's web magazine, The Verdict, and a very popular blog that he runs called Dorf on Law. When he's not being cited in major publications, including the New York Times, he maintains an active pro bono practice that chiefly consists of writing amicus briefs. He's a graduate of Harvard College and Law School, as well as a clerk for Judge Reinhardt, and a former clerk for Justice Kennedy of the Supreme Court of the United States. He was also a former professor at Columbia. These are some of the nation's top scholars, and I'm so excited to hear what they have to say about the future of university. I'd like to invite President Peñalver to please begin the conversation.
Great, thank you, Sheetal. Mike, since you're a con law expert, before we get into some of the specifics of things that are happening at universities, I thought maybe we could step back a little bit and just talk about executive power more broadly. And some of the things that the new administration has done that feel quite different, focusing on withholding federal funds, changing the NIH overhead rate, some of the more intrusive interventions in university life have really revolved around what we might describe as a kind of internal workings of the executive branch, right? The executive, the president, taking action kind of within their domain in ways that are new, and feel from our, from the point of view of the university, quite different and intrusive. What do you see as novel, and what is sort of not new about President Trump's approach? What, from the standpoint of executive power, as opposed to like the specifics of how he's deploying it?
Yeah, so I think all of the major actions are novel, but I would distinguish not between new and old, but between those that are sort of continuous with what we think of as the traditional conservative view of the executive branch, and those that are distinctive to President Trump's view about power. So the ones that I think of as continuous come out of what's known as the unitary executive theory. So for those of the people in the audience who don't know, right, the Constitution divides power between Congress, the president, and the courts. And the first line of Article 2, which sets out executive power, says the executive power shall be vested in a president. Proponents of what they call the unitary executive theory say, aha, that means all of the executive power is vested in the president, and therefore any limits on how the president runs the executive branch are unconstitutional. And so President Trump is surrounded by people who believe in a very strong view of the unitary executive. There are people I think of as sort of ordinary conservatives who also think of this. But one way to understand a kind of normal Republican view of this is what they're doing with respect to independent agencies. So since roughly the New Deal, a little bit goes back a little bit earlier, you can find precedent during Reconstruction, but Congress has created agencies that are headed by commissions made up of people who can't simply be fired at will by the president. They have tenure protection. This has long been an annoyance to people who believe in the unitary executive, because they say, well, look, the president has to be able to supervise the executive branch, and so he should be able to fire anybody who's not bending to his will. And so they've been doing that. They've fired members of the National Labor Relations Board, other people who have that kind of protection by statute, which says they can only be dismissed for good cause. Those cases are now in the courts. Some lower courts have enjoined this practice. And that's going to make its way to the Supreme Court. And just for the sort of technical wonky issue here, there will be the question of whether the Supreme Court decision from the New Deal era called Humphrey's Executor against the United States should be overruled or not. I think of that as sort of normal churning of constitutional doctrine. The country could survive without Humphrey's Executor. I wouldn't like if the court overrules it, but in practice, even independent agencies are often quite responsive to the president. The one exception to that is probably the Federal Reserve Board, which sets monetary policy, for which it's a terrible idea to have direct presidential control. But interestingly, the presidential executive order setting out this view of executive power purports to exempt the Federal Reserve from this control. Okay, that's the normal stuff. What I regard as the abnormal stuff is using the levers of power essentially to control, or in some cases take revenge upon, those institutions and actors that the president views as his political, or in some cases personal, enemies, right? So here, I think the clearest example concerns the targeting of law firms, in some instances simply for having among their numerous partners people who previously represented interests adverse to President Trump, and trying to get them to change their policies by freezing or canceling any kind of federal contracts, warning clients that if you do business with this law firm, you won't get any federal work, and essentially trying to rein in that kind of opposition. I see the efforts with respect to journalists in a similar vein. There, they haven't done nearly as much, but you might have seen yesterday the Associated Press won in the lower court that the president can't simply exclude the AP reporter from the press pool for refusing to call the Gulf of Mexico the Gulf of America. That's kind of a relatively unimportant issue, but I think it's sort of emblematic of this second bucket of actions. And then the third, of course, concerns universities. And we'll talk about that a bit more, I'm sure. But one way to understand the attack on universities is that it's a result of a perception of universities as a source of potential resistance to the president's agenda. This is very common in authoritarian regimes, that you don't want academics, scholars, and others speaking out against your policies, even if it's on matters of science, right? So, the Health and Human Services Department is headed by Robert F. Kennedy Jr., who is a vaccine skeptic, has a bunch of other eccentric views. He might not like the fact that there's NIH funding going to vaccine development. He might want it to go to something else. But more broadly, I think he and the administration more broadly perceive universities, lawyers, journalists, probably other sorts of institutions and actors as people and institutions to be controlled and have their power minimized.
Yeah, there's a lot there. And I think let's start with universities. I mean, and I hope we can get to the law firm topic and maybe some broader framing of these mediating institutions generally, because maybe at the most basic level, the question is, does the federal government have the leverage to silence all these groups which are operating in our system in the private domain? But let's start with universities. One of the ways the administration has sought to exert leverage over universities is by withholding federal research grants that were already awarded and kind of in progress. And this happened, or at least it was announced in the news yesterday at Cornell, and like $1 billion of grants that are being frozen, supposedly, Northwestern. But it's over the past few weeks, it's been many schools, Columbia, Brown, Harvard, Princeton. First of all, what is the power of the government to change those grants midstream? Are there legal limits on its ability to sort of renegotiate the terms of grants that it's already awarded?
Yeah, so it depends on the reason. I talked to a colleague of mine in another department who has one of these grants not yesterday, 2 days ago, and reviewing the terms of the grant. It is in the nature of a contract. I did some research that was funded by the NIH a number of years ago, and I didn't pay attention to the fine print because I didn't think this was relevant at the time. And thankfully, that grant has expired. We spent all the money. We published all the papers. But the it is a typical term in those funding grants that they can be canceled by the funding agency based on a kind of realignment of the agency's priorities. So just to give a sort of hypothetical example, imagine that the government is funding, half a dozen studies to find a drug that will be effective in treating some new pathogen. And midway through the study, one of the researchers, grant funded, comes up with a miracle cure. You could see why the government would want to say to the other five at that point, all right, stop your trials. We've now got what we need. Or, it could be that whatever the pathogen is circulating wanes or something like that. So that's normal, and that does happen from time to time. That's not what's going on here, right? I could see that happening with some things, right? You could see going forward that the Department of Energy would say, well, instead of looking for, studying how to make solar panels more efficient, figure out ways in which we could benefit from global warming and, study the health benefits of inhaling pollution from coal or something, like that. I would oppose that on policy grounds, but that is sort of within the bounds of a normal activity. What's happened here is that the government or the executive branch, President Trump, is using the leverage of these federal grants to get other policy priorities. And so the three ones that are most important are the ones that Sheetal mentioned at the opening, right? They want universities to abide by their views about transgender female athletes. That was the reason given for cutting off funding to the University of Pennsylvania and earlier to some agriculture department funding to the University of Maine. They want universities to stop practicing DEI, diversity, equity, and inclusion. That's cited in various of these. And they claim that universities have not been doing enough to combat anti-Semitism on campus. Okay, some of those goals are substantively problematic in various ways. We can get into that, but I want to bracket that for the moment just to say that if the government is going to cut funding because of one of these extraneous reasons, it's not because we don't want to fund your study anymore, it's because your university is engaging in race discrimination, let's say. Anti-Semitism is defined in the case law as a form of race discrimination, right? The government can do that, but there is a federal statute that explains all of the steps it has to take. And these are pretty important steps. So it has to conduct an investigation. It has to give the university an opportunity to review the information. It has to allow for the university to make prospective changes. So the goal of the Department of Education investigation into civil rights violations is not punitive. It's not backward looking. It's forward looking. When there is a violation found, any funding cutoff is supposed to be limited to the subunit of the university that was in violation. There has to be a report to Congress. There's a whole list of, I would call them procedural hoops, but it's important to go through them because they ensure that you're actually, targeting real violations rather than just imposing your will. The administration has done none of that. It's just announced, well, we opened an investigation. We're not concluding the investigation. We're not following any of these steps. We're just saying you're not getting the rest of your money. So these are blatantly illegal funding freezes, which is why, people like me and various others have urged university administrators not to simply acquiesce in them. Now, having said that, I understand the enormous pressure on people like you and other university presidents threatened with funding cutoffs, or in some cases actually experiencing the funding cutoffs, which is that it can be illegal, but that doesn't mean that you're going to get the funding restored immediately. You have to go to court. You have to fight. You have to win in court. You have to get the government to comply with the order, which is not something that's happening these days all that rapidly. And you have to ensure that it's preserved on appeal. And even if you win all of that, right? Then the question is, well, what happens for the next cycle of grant funding? Even if you get your money restored from last year's grants, or if they're longer term grants, a few previous years, now they're not going to give you future grants. And that would also, in my view, be unlawful if done for retaliatory purposes. But that's going to be very difficult to prove, and you have to prove it on a case-by-case basis. So I totally understand why Colombia, for example, kind of capitulated. Although, to my knowledge, it still hasn't worked. They haven't gotten their $400 million back yet. Capitulation was just the first step in getting the administration even to sort of consider restoring the funding.
And what does this say about, I mean, it's interesting, your point about just the illegality of this, let's say, and yet the difficulty for an organization like even a large university like a Columbia or a Cornell to risk the loss of these funds in the short term because of the impact it has on operations in order to prosecute a legal challenge. I mean, what does that say about the effectiveness of the judicial system as a check on executive power more broadly, especially when the executive is motivated to act at this scale, right? So if we were talking about individual grants, it'd be no problem to just sort of litigate these, and it could take 3 years and that would be okay. But in some ways, the scale of the ambition here, cutting $1 billion of grants, it makes it more obvious that the action is not legally sound, but also more challenging to bring the legal action to demonstrate that. So, like, what does that mean for a theory of judicial review that we've relied on as a guarantor of our rights more broadly, not just in this narrow context?
Yeah, so I'd say two things. So one is, to some extent, this is ubiquitous in the legal system, right? Everybody knows that you can have a good case in law. Facts can be on your side, but it could take years to get what you want. And this is why potential plaintiffs or actual plaintiffs often settle for a substantially lower dollar value than they could get if they saw the litigation to the outset. You reduce the uncertainty and you get money in hand rather than having to wait. So that part, I think, is normal. What's different here is that this is the executive branch of the government, of the federal government, right? So if you're in litigation with another private entity, you know that at the end of the day, if you win, that the courts will be able to enforce the judgment against that private party, and that there are coercive measures the courts can take against them. The worry we're facing here, I think, is a worry that goes back to the founding of the country. So James Madison was originally he and Thomas Jefferson. Well, no, he had this colloquy with Thomas Jefferson in letters, but he was originally opposed to a Bill of Rights. And the reason he thought he was against a Bill of Rights was he said that it was a mere parchment barrier, meaning it's just a piece of paper, right? If the government wants to violate it, then they'll just violate it. He thought the solution to that was creating institutions that would be strong enough to defend themselves. And for 235, 40 years, that seemed to be true. But we're now not talking about just the Bill of Rights. We're talking about all law. And what we're learning, I think, is that law is ultimately dependent upon people in power acting with sufficient goodwill and respect for the rule of law. So this is not entirely new in the history of the United States. There's a famous but almost certainly apocryphal story told about President Andrew Jackson in response to the Supreme Court's decision in a case called Worcester against Georgia involving Cherokee removal. And he said, John Marshall, the Chief Justice of the United States, has made his decision. Let's see him enforce it, right? We worried about this when President Nixon was thought might not turn over the tapes, even though he was ordered to do so by the Supreme Court. And so an executive branch that doesn't comply with judicial orders can't be reined in by the judiciary. Alexander Hamilton in Federalist 78 refers to the judiciary as the least dangerous branch because it lacks both purse, meaning the power of the purse, which is vested in Congress, and sword, meaning the military. I mean, what we're learning now is that maybe Congress, so Congress could, I think, rein in the president a little bit, but they're not doing so. And so in the absence of Congress, I don't see how the courts can fill that void unless the administration is going to abide by court orders. And the only thing that I think is going to get them to do that is some kind of public pressure.
So our whole system, not our whole system, but a huge part of our system of research and innovation in the United States is built on a system of federal funding of university research and research outside of universities. What does this mean? What do these cuts mean for the future of that system, that way of creating innovation, that way of doing research? Is this do you kind of looking forward? Do you see a scenario where this is a sea change and we're going to move away from federal funding back towards more, what we had before the World War II, of kind of more private funding of research? Or do you think this is something that, if at the end of this administration, could be undone by a future administration?
So in theory, it could be undone, although I think even in the best case, it takes a long time to undo damage, right? It's always easier to destroy than to build. And that, some universities might not survive, or might not survive in the form that we've grown accustomed to. So, but I think the sort of most optimistic scenario is this is a very dark period, but it's exceptional. And then we go back to the previous model, having lost a lot of ground relative to the rest of the world, and also just relative to the challenges that people face, right? That is, somebody who would have discovered a cure for some terrible disease now doesn't discover it for five additional years. In the interim, people who could have benefited from the treatment are not going to, and will get sick and die. So there will be real costs to doing that. But that's the best case scenario, is that we get back to that. I think there are two other kinds of possibilities. One is that this moves to within the government. So, none of we have government funding for research. The government does some of its own research. You could build up the capacity more within the federal government. I don't see a large appetite for that, because in a world in which there is a sort of, a realignment and people go back to the way they were, I think, well, we ought to have a big budget for research again. I think the universities would be the most logical place to lodge it, but that's a possibility. And then the third is what you said, which is that it's just left to the private sector. Private sector is very good at doing applied research, coming up with profit-making devices, innovations, etc. There have been in our history some private entities that also do basic research. So Bell Labs was famous for doing this for many years. Both Alphabet, the parent of Google, and Apple do have sort of basic research arms within their corporate structure, and there are other corporations that do that. They do that because they're farsighted. They have they see themselves as benefiting from the scientific discoveries through future marketable innovations. But that means that certain kinds of funding in basic research that don't have even medium-term economic payoff will be grossly underfunded. Maybe that moves to other countries, India, China, the European Union. And, that's bad for the United States economy, but not so terrible for humanity if we're discovering these other things. I think at the very least, the defunding of the universities will cause a serious decline in the United States' sort of standing in the world and its standard of living.
Yeah, no, in some ways, our research universities are the world's research universities, and And this does call that into question. And that leads to the, another area of federal action that I wanted to talk about with you, because it's happening, even as we speak. I mean, it started with the detention of non-citizens, people who are legally present in the United States, some on student visas, some on green cards. It seemed like it was in response to controversial speech the administration doesn't agree with, largely related to the protests last spring. In recent cases, it's just been, it seemed a little bit random. Students and recent graduates here on professional training, with professional training status, have had their visas revoked, seemingly for kind of often minor infractions. What are the legalities of revoking immigration status, and kind of if you think about that first category, are there First Amendment protections against that? And then for the second category, are there other protections for people who are here on, legally on some kind of temporary status?
Yeah. So the government can deny a visa for almost any reason. The cases are pretty clear that non-citizens outside the United States don't really have free speech rights, although US citizens do have some First Amendment protection with respect to hearing what those non-citizens have to say. So interestingly, the first US Supreme Court case ever to strike down a federal statute on the basis of the First Amendment is a case called Lamont against Postmaster General. And that involved somebody who wanted to receive in the mail what the government was labeling foreign propaganda. So the right to free speech includes the right to receive information. And so there is some protection for that. But of course, you can receive the information, as in the Lamont case itself, from people who are outside the United States. So that provides a tiny bit of protection, but not that much. Once people are here, they do have free speech protection, but there's not a lot of good case law involving the interaction between the immigration law and the free speech protection. So if somebody is here on a visa, yeah, they have a right to speech, but the government can also revoke their visa. So one of the statutes that the Secretary of State has invoked gives him the authority to revoke any visa, including that of including a green card, right? Someone who's a permanent resident of the United States, apparently, on the ground that that person's continued presence in the United States is contrary to the foreign policy interests of the United States. Now, that is an enormous power. In my view, various federal cases and statutes provide at least procedural protections that the administration should be, but apparently so far is not following, that say that, well, if you're going to say somebody's continued presence here is not in the foreign policy interests of the United States, first of all, that has to be your actual reason, as opposed to you're just punishing them because of their speech. And second, there should be some judicial review of that, but that's an open question whether there is. So, there are, I think in my view, there are two problems here. One is that the case law isn't sufficiently robust, although there are cases, as I say, saying that people here legally have a right to free speech. But the other is that Congress has delegated vast discretion to the president and the Secretary of State in this area in a way that it really oughtn't to have, right? That is, and it's short-sighted, because part of what builds prosperity and a robust society for the United States is being an attractive place for non-citizens to come to visit, to study, maybe even to settle. And by making anybody's continued presence in the United States subject to the whim of the Secretary of State or the president, we dissuade people from coming here. So it's not just the problem that, a lot of foreign students are understandably very fearful now and keeping a very low profile. It's that potential future foreign students deciding whether they want to, study at Cornell or the University of Toronto or, University College London are going to go to one of those other countries because they don't have to deal with this, a very, very difficult situation created by the arbitrary enforcement of the immigration laws.
But your response raises two questions for me, and I'll start with the first one, which you talked about the benefits of these students. I share that view, the benefit of these students to our institutions, but also to the United States, to the dynamism of our society and our economy. On the other hand, the Vice President J.D. Vance has said on at least one occasion that he sees foreign students as sort of taking seats that belong to American students. I mean, is that the goal here? Is it, notwithstanding these kind of national security justifications, do you think the purpose of this behavior is to deter students from coming into the United States and to kind of encourage people to go elsewhere?
I think that's part of it. You see this is part of the rift within the Republican Party, right? So the Elon Musk wing of the party wants highly skilled foreigners to come to the United States where they can be employed and part of creating our robust sector. But part of it is just the attack on universities more generally and anti-immigration sentiment. I mean, to the extent that Vance is making a coherent argument, it's coherent, but it's factually flawed for two reasons. First, it just misunderstands the way economics works, right? That is, the economy is not a zero-sum proposition. People coming from other countries to study in the United States and contribute to our economy grow the pie for everybody and contribute to prosperity that can be widely shared. But even on the narrower question, it's just not true that foreign students are taking seats that would otherwise be occupied by US students, because for the most part, people, when they come to the United States from another country, pay full freight, whereas US citizens are generally eligible for all sorts of scholarship money. And so really what's going on with foreign students, putting aside the researchers who are on faculties and so forth, but with foreign students is they are subsidizing US citizen students and thus not taking away seats, but making it possible to educate more US citizens, not fewer.
But the second question that your response raised, it kind of echoes something we were talking about in connection with the federal funding, which is the challenges of judicial review as a check here. In addition to the delegation that you mentioned, from Congress of this power to the executive, there's also in the process of judicial review a tendency by courts to give a great deal of deference to the executive on questions, especially of national security, and there's just a kind of reluctance to go there. And you see this, and foreign affairs generally, right? And you see this in the arguments that the administration is making right now against its obligation to bring back this person who was deported to El Salvador, apparently in error. And they're saying, well, you can't force us to fix this because, this is foreign policy. And courts, it'll be interesting to see what the Supreme Court does with that. But historically, courts have been very deferential to the executive, in the area of foreign policy generally, and certainly with respect to national security. And, you can see why, right? I mean, you can understand why you don't want, an unelected judge, kind of second guessing, very subtle judgment calls that the president or national security staff might make about this or that. It relies, but that deference relies on the assumption of good faith on the part of the executive. So, when you don't have that, it's not clear what the right answer is. But all of these kind of challenges of using the judiciary to check the executive in these areas where the executive's kind of looking like it might be going rogue, lead me to this broader question, and I'm thinking of some of the discussions from several years ago of, largely from constitutional scholars on the left, critiquing over-reliance on the courts, and people like Mark Tushnet, and the sort of popular constitutionalism and the need for sort of a politics of constitutionalism. And is that the answer? Is it sort of a popular movement in support of constitutional norms outside of the courts and outside of Congress?
I like Mark Tushnet very much. I respect his work, which I think is terrific. It's not just him. There are a lot of other people who've said this, and you're right. It's often coming from the left. We can think of, or coming from people who are sympathetic to the goals of the Warren Court, let's say. So Gerald Rosenberg's book, The Hollow Hope, right? Can courts bring about social change? The answer he gives is no, right? I think there's a bit of a false dichotomy set up in this kind of a critique, right? That is to say, it's not as though liberals or progressives ever had a meeting at which they decided, you know what, let's give up on politics and throw all of our effort into securing our goals through the courts. Courts were almost always used either as a last resort or in combination with a political strategy. So I certainly agree with the claim that nobody should simply rely on the courts as the means of combating bad or counterproductive or other kinds of policies that you don't like. Of course, there should be political action, but heretofore, at least, courts were one of the sites in which we could make our arguments and hope to get some kind of relief. Now, it doesn't always mean you win. Sometimes, my day job is I'm a constitutional lawyer, but one of the things I do, so one of my other interests is because I'm a vegan, I do some work in animal rights. And I've written amicus briefs in cases involving elephants and chimpanzees and so forth, and we almost always lose. But that doesn't mean that it was pointless. Sometimes you lose in the court, but you move public opinion because you get useful publicity. And this isn't just true in animal rights; it's true of lots of causes that you can win by losing. There's something to that. When we and I do think that if the Trump administration actively defies the U.S. Supreme Court, right, a Supreme Court with a 6-3 conservative supermajority, including 3 of his own appointees, I think that has a potential effect on public opinion. So, the president has said he will abide by judicial orders. Hasn't exactly done that consistently, but he claims that that's his position. And so my view is let's put that to the test rather than abandoning the courts, right? But it's not a question of do we do this other thing instead of going to the courts. It's yes, do this other thing in addition to going to the courts.
Both hand. One area of litigation where the courts have been very sympathetic are claims of religious freedom, and I want to kind of go into that a little bit. Seattle University is a Jesuit university. In some recent public statements, Georgetown has made some comments about the linkages between its Jesuit mission and both its protection of freedom of expression on campus. So they had a student or a postdoc who was detained for protest activity around the war in Gaza, and they were saying we need to maintain a certain kind of campus climate that involves robust exchange of ideas and freedom of expression because of our Jesuit educational mission. At the same time, linking commitments to diversity and equity and an inclusive campus environment to that Jesuit mission, seemingly kind of teeing up an argument that this is a matter of religious freedom for them. How optimistic should we be that the court will continue to be solicitous of religious freedom in support of these goals that are not the ones that have been the kind of subject matter of the cases that have been brought in recent years?
I think the answer to that is somewhat, right? So there, in recent years, this is a kind of strange set of cases, but there are these cases in which people who are condemned to die by execution have sought to have clergy present with them within the the death chamber, successfully, and they've brought these successful challenges. And it has been not only Christian clergy. There have been cases involving Muslims and other people of other minority faiths. And I do think that the Supreme Court is generally sincere in extending religious freedom to people who are taking positions that might be at odds with whatever the particular ideology of the broader conservative movement might be. And so that if the Georgetown or Seattle University, if faced with it, could credibly say that these aspects of DEI are part of our Jesuit mission, I think they would get some credit for that. I don't know how well that survives in a conflict with the kinds of immigration concerns we talked about. And there, my main evidence is from the first Trump administration. So the very first days of the first Trump administration, they adopted what the so-called Muslim travel ban, right? And that was struck down by lower courts. They went back and they revised it 2 times. So the third version of it finally makes it to the Supreme Court in a case called Trump against Hawaii. And the core argument was that this is religious discrimination in violation of the First Amendment. And what the Supreme Court said was, well, maybe, but in any event, the government gets super deference in matters of foreign policy and national security. And so, in a conflict between religion and a perception of national security, I think religion loses. In other conflicts, so this might be with respect to something like DEI, I think the religious institutions have a fighting chance.
Thanks. A question from the Q&A, which kind of follows on our earlier discussion of how universities should respond to these cuts in their federal grants and the challenges of the length of litigation. Asks about endowments. Many of the universities that have been targeted, I would say most of the universities have been targeted for these funding cuts, at least so far, have been universities with multi-billion-dollar endowments. Harvard's endowment's over $50 billion. Columbia's is also not that large, but very large. The question is, why don't they tap their endowments? And I have some thoughts on that, but I'm curious if you want to weigh in. I think there's a lot of misunderstanding about what endowments are and what they're not.
Right. So you can speak to this, I think, from greater expertise than I can, but my understanding is that the bottom line figure of an endowment is the aggregate of lots of different funds, many of which are specifically targeted for, one particular purpose and cannot be diverted to general funds. Moreover, endowments have a payout rate that is typically, 4 or 5, maybe 6% in extremis. And so, if you have a $10 billion endowment, that doesn't mean you can just spend $1 billion in a single year. So there's that. In addition, I think, right, I think it's a mistake to think of the cutoff of $1 billion to Cornell as really targeting just Cornell, right? That's $1 billion in research. Now, some of that money goes to pay for overhead. And so if Cornell can't spend that money, there will be people who will have to be laid off. Johns Hopkins, which is a major research institution, has laid off hundreds of people because of prior cuts, mostly involving USAID. That's not money that's going to educate students. So I think that there's just a kind of mismatch between what an endowment is and the ability to fund research. Now, maybe you say, well, but don't they have a kind of rainy day fund? And to some extent, yes. But the fact that Harvard is now going into the financial market to borrow hundreds of millions of dollars, right? They're not just writing themselves a check. That tells you that they are cash strapped from tapping their endowment, because if they could just tap their endowment, it would be much cheaper to do that, given that, if I sort of read the financial news today correctly, right, the bond market is tanking. When bond prices go down, interest rates go up. So it's very expensive to borrow money, much cheaper to just spend your own money. The fact that they're not doing it tells you that they really can't.
Yeah, the endowments are really, you think of an endowment, it's really an aggregate of a lot of little endowments, that are restricted, as you said, and there are some that are open-ended and say these can be used for whatever purpose the president or the dean deems most important. But that's a although deans and presidents love endowments like that, they're not most endowments. And I think one estimate I read was maybe it's a fifth or so of the typical endowment will be in that unrestricted category. But then they're all restricted by a fiduciary duty not to spend into the principal, right, to make them endure, which limits what you can, if you have a $1 billion endowment, in a normal year you would get 5% of that to spend, and you can go up a little bit, but you go beyond a certain point and you're violating your fiduciary duty to the institution, future generations of the institution. Now, I think there are arguments you could make about the kind of extremist situations where where it would be in the best interest of the institution to go beyond the 5% or 6%. But those purpose restrictions are very significant and legally binding, and even if it becomes impossible to pursue that restricted purpose, sometimes you have to go to at least in Washington State, you have to go to the Secretary of State and ask for permission to change the purpose of a restricted endowment. So it's a lengthy process. It's not like a slush fund. And this is where, again, the scale of these cuts is so significant, because universities, even very well endowed universities, tend to operate to the limits of their budget. And they count on the endowment. They also count on those federal funds in kind of planning. And so then when you get a sudden loss of revenue, you don't have a lot of spare money around. You have some, but not everywhere to just sort of keep rolling. And the most natural response is to, as you said, do what Johns Hopkins is doing and really, reduce your operations. The one last, we have about 7 minutes left. I just wanted to ask about, again, about kind of university responses in the past year or so. A number of universities have signed on to an approach to institutional speech, and this feels, this feels quaint almost to think about right now, but based on the so-called Chicago principles, which are themselves based on a Vietnam era committee that the University of Chicago stood up called the Calvin Committee. It was charged with asking what universities should be doing in response to controversial questions, and the Calvin Committee said, universities should just not weigh in on controversial issues. There were some exceptions to that based on the sort of university's truth-seeking mission itself. But one problem I think with the Calvin Committee approach is that concept of what's controversial, and because really any things that seemed uncontroversial can become controversial, and the idea, right, that the government shouldn't target law firms that take positions that are contrary to the personal interests of the president or something, feels like it 10 years ago would have been an uncontroversial thing to call a bad thing, and now it's been done. And so if a university or a law school weighs in and says, this is a real problem, they're taking a position on a controversial question. What's your view on this? Like, what is the proper institutional role, in terms of speech of universities in addressing some of the things that are going on? And what are your views on the Calvin Committee insistence on institutional neutrality?
Yeah, so I should say that I served on a committee. It does seem quaint now. Beginning end of last academic year, so starting around May of 2024, extending through the end of last semester, that was tasked by the president of the university to consider how we ought to modify our principles governing expressive activity on campus, how to balance inclusion versus free speech and so forth. And we had lots of discussions, including a bit about the Calvin principles, although ultimately we decided that was beyond our charge. Now there's another committee that's been designated to address that. I came to the view that I totally understand the appeal of something like the Calvin Report approach, right? Because if the university, as an official matter, weighs in on anything, it's going to be charged with hypocrisy or betraying its values or not weighing in on any particular additional cause, right? So, so you care about this, but not that, and so forth. So that's the core appeal. But I also think that for the reason you say, right, what's controversial, et cetera, it becomes very difficult. And let me just give two illustrations. So one is, what happens when somebody on your campus says something vile, but that is nonetheless protected speech? It could be a professor who's doing it, not in class where it might be, a violation of their teaching duty, but, on a television show or in an op-ed or something. It could be a student at a rally, right? The conventional answer is it's the job of the university, and this is actually required by Title VI or Title IX, depending on the nature of the speech, right, to engage in counter speech. This is this idea closely associated with Justice Louis Brandeis, that the proper response to evil counsels is wise counsels, right? So counter speech is now going to be, right, on something that apparently is controversial, right? Because it wasn't controversial before, but now it is. So that's one problem, is engaging in counter speech. The other problem is that there are these exceptions to the Calvin principles for matters that affect the university directly. And so much of what's going on right now affects the university directly, so that even if you adopt a robust version of the Calvin principles, unless you're going to say, and there are no exceptions, you're going to find yourself potentially in hot water. And also policing the bounds of what does and doesn't affect the university directly is going to be problematic. I think if I were in university administration, I would draw a sharp line between official statements on behalf of the university and statements by university presidents, law school deans, acting in their individual capacity. I don't see why there actually is a need for the university to make these official statements. And I think you get almost all of the juice you can out of it by statements in one's personal capacity without running this risk. Although it still does run the risk of putting you in the crosshairs of the current administration in Washington.
Thanks. Mike, we're pretty much at time. We're at the top of the hour here. So, we could go on for another hour easily on these topics.
Can you? I'm sorry. Yeah, I just wanted to also just maybe 30 seconds or 40 seconds, even though the future is what we wanted to talk about, is what is the future of universities, right? I mean, what happens to science research? What happens to foreign students? What happens to even academics who are, citizens' ability to speak when there's all these looming threats? So maybe you could just tell us the different scenarios in your mind, Professor Dorff.
Well, I mean, I think the short answer is we don't know. I think there is an existential risk to universities. So Chris Eisgruber, the president of Princeton, said the other day that he thought that universities were facing the greatest threat since the Red Scare. I would say it's a greater threat than at that time, at least to the university as we have come to know it. But to my mind, that's a reason why we ought to, speak up and, make as much noise as we can now. In general, the pattern of authoritarian takeovers is that it's easier to resist them earlier than later. And so, people who care about universities, like people who care about democracy, have a reason to try to defend universities right now, and not in a sort of defensive crouch, but to make the kind of robust case for why universities are central to the American democratic experiment and to the prosperity of the country, and indeed to the world. Right? This is not a zero-sum situation. I don't think that argument is going to be persuasive within the White House, but it might be persuasive sufficiently among the greater public to sort of change the political dynamic.
Thank you so
Mike.
much. Thank you so much,
Thank you.
Professor Dora, President Penelver, Eduardo, Mike. It's been such a pleasure to hear you. It's always is a delight to hear your thoughts. And even though we are facing this grim future, but yes, we all need to get on board and act up, as you say, and defend universities. Thank you to Shannon Young for organizing this, and also for all of our sponsors: Indian American Community Services, Indian American Impact Foundation, South Asian Bar Association of Washington, South Asian Public Health, Traveling South Asian Literature. So many people are intrigued and interested in this conversation, and we really appreciate this important discussion. So thank you again. And thank you for the
Thank you
audience for attending.
Thanks.
Thank you for the great questions.